Welcome, everyone. Thank you so much for being here today. I'm Lindsay Gray. I am the CEO of VECINA, and I'm here with Kate Lincoln-Goldfinch, our board chair. Hi, Kate. How you doing?
Good, how are you? I'm like simultaneously trying to share this video, so if you see me
Yes,
looking.
no. Well, Kate and I are back. We initially actually thought that we recorded this video, was it Tuesday or Wednesday?
I
Um,
don't
and we did a 40-minute video. It was fantastic. And then and then we both got offline and realized that in fact we had not gone live. So here we are again to talk to you about the new asylum rule. So I see on Facebook that it is going live. Can you see that, Kate?
I can.
Okay, perfect. Then I'm going to put this away over here. And then I am going to share my screen with our PowerPoint. See, we worked quite hard on this. So that's why we had to redo because we felt
You did. I did not work.
well,
Your effort.
we as a team, we put a lot of effort in because these new asylum regulations are really important. And it is, I should say, hopefully the Trump administration's final attempt at a blow to asylum in the United States. So we're hoping that these regulations are stopped by litigation. And of course, if not that the Biden administration publishes new regulations to basically overturn these, but that would take some time. So there is a decent chance that these will go into effect at least for a period of time. And so we wanted to spend some time with you all going over them.
Well, Lindsay, you may not know this, but I keep a crystal ball here at my desk.
Oh, I did not know that.
And so when I consult with my crystal ball, here's my guess about what's going to happen. I think so many of these parts of this, massive 400-page regulation are going to be headed toward litigation and probably at least injunction in whole or in part. So I think we're going to, as attorneys who do asylum cases, we're going to have a mad scramble to file I-589s for our affirmative or our defensive cases before January 11th, so our clients are not subjected to these new regulations. Then there's going to be litigation and probably an injunction, which, at this point, immigration lawyers are used to this because it's like, oh, the filing fees are going up, or there's new EAD regulations, or whatever it is, and we rush, and then it gets blocked by the courts. So we're probably going to experience that again, which is a little bit of a bummer for the holidays, for those of us who have lots of these to file. And then, because this is a regulation that followed the procedure under the APA, there's a, proposed regulation, a notice and comment period, and then a final regulation publication date. And that requires a period of time, several months. And so even if the Biden, let's say there is no injunction, and if the Biden administration does want to roll back these regulations 9 days after they go into effect when he assumes his office, they are going to have to follow the APA procedures to roll back the regulations. So my guess is there is going to be some sort of injunction, whether it's in whole or in part, and if not, the regulations will be rolled back hopefully by the next administration, but there's this window of time when they will be in effect. And so as immigration lawyers, or if someone watching this is an asylum applicant themselves, this deadline is rather important of January 11th to try and file the 589s first, because it is not a retroactive regulation, meaning for those people who have already filed their I-589s either with the court or with the asylum office, you're not subjected to these new regulations. So
yes, that's probably the most important thing we have to say today is that if you have I-589s to be filed, you should do everything you can to get them filed prior to January 11th.
right.
All right, so let's dive into the rules. So the first thing we're going to talk about is expedited removal and credible fear proceedings. These are proceedings that, with our work on the border with the institution of the migrant protection protocols, we don't actually see as much as we used to, but they are still happening where folks come to the border or are picked up by Customs and Border Protection, and they get basically an interview to talk about their story, their reason why they fear return to their home country. And so now there are some changes to that process, such as consideration of precedent, a higher standard for withholding of removal, which is a sort of subset or a type of relief that you can get if you're not eligible for asylum. And then also at the end of credible fear proceedings, if you have a negative credible fear finding, it used to be that you just automatically had a review by an immigration judge. And now that's not true anymore. You waive your right to review by an IJ unless you affirmatively request such review. So Kate, you've had a lot of experience with credible fear proceedings and preparing people for credible fear proceedings. Can you talk about sort of the practical implications of this?
For sure. And, this is the procedure we've had in place since IRA was passed in 1996. And the flow of an asylum applicant is they present at the border, either they at the bridge and they ask for protection, or they enter without inspection and get apprehended. And the system by which we as a nation have screened people for asylum is through this interview process, where pretty quickly after they get apprehended or come to the border, they meet with an asylum officer and they're interviewed about their story. And it's usually about an hour, 2 long interview, and they just tell their story. And the credible fear, or the asylum officer, is supposed to be determining whether this person could potentially qualify for asylum, right? And if they can, then they should get through this screening mechanism. It's meant to be a pretty wide net, so then anyone who could potentially qualify gets through. And then what happens is, ideally, they get out of detention and they start preparing for their final hearing. They find an attorney, they start gathering their evidence, preparing their testimony, looking for an expert. It's a very in-depth, involved, long process. And for attorneys who do this, you guys know, to do this well, we need at least a month or 2, ideally several, to do this really well, to really prepare our clients, to help them, process, get through their trauma. Maybe they need to be working with a psychologist, and things sort of slowly come out over time as we're working with clients. And so the problem here with this change is that now there's going to be more barriers at the credible fear interview process, where asylum officers and immigration judges who are maybe doing a review of a denial of a credible fear interview can consider other things like precedential decisions or internal relocation, like other legal barriers to asylum. And the problem is that this is meant to be a very early, quick screen. And so asylum seekers typically don't have an attorney for this part of the process. They're not really oriented to our system. And so they kind of go in blind. And so the expectation that they would be prepared essentially to have their legal argument all put together is absurd. And so one of the things you'll see as we talk through these regulations is, they're calling this the death to asylum regulation, because it's like, it is just slashing through asylum eligibility. And it's essentially a regulation that contains almost all of the policies that the Trump administration has put into place over the last 4 years to try to block asylum, especially for Central American asylum seekers. The other point that I'll mention is this higher standard for withholding cases. The way to think about that is the burden is, rather than a significant possibility of persecution, the applicant now has to prove a reasonable possibility of persecution. And the way that they show that numerically is, rather than it being more than 10% likely that you'll be persecuted, it's now more than 50% likely. And that's always been the case for withholding of removal interviews, but it's now following all the way through the case. And it's being applied more broadly.
So moving on to the definition of frivolousness, I think this is one of the, major issues in the rules, especially as case law regarding asylum is changing so rapidly. And so it used to be that with frivolous, so I guess I should walk back and talk about the consequences of filing a frivolous asylum claim. If you are found to have filed a frivolous asylum claim, the person is barred from most eligibility for immigration relief, generally, for forever, from my understanding. And so it's a big deal to have been found to have filed a frivolous asylum case. And what it used to be was that filing a frivolous asylum case was essentially one that was not based in fact, right? One that you made up, that you lied about, that you falsified. That they are changing that definition and now saying that frivolousness includes any application that's clearly foreclosed by law. Well, if you've been following along at all with how the asylum cases and the law has developed over the last 4 years, there's been a lot of the Trump administration actually referring cases to themselves, which we could go into why that happens in a court, but it happens in immigration court, and overturning good case law that's favorable to asylum seekers. So, for example, if you were a domestic violence victim and you were unable to leave your relationship, there was a good case out there that was helpful, and the Trump administration referred another case to themselves and essentially overturned that case. And so now, are these cases that are making their way up past the Board of Immigration Appeals to circuit courts, can we just not file them because they're all going to be found to be frivolous? And I think that that's going to be a big concern, that attorneys are going to start shying away from creative arguments because they're scared of a frivolousness finding for the consequences to their client. And I'm sure that there are judges out there that are going to start threatening ethical sanctions against attorneys as well.
Yeah, I mean, completely. And this last bullet here about the actual knowledge or the willful blindness. So historically, actual knowledge is required to, commit frivolousness or, submit a frivolous application. And now this idea that you can just be willfully blind, which means, pro se applicants and attorneys who may not be up to date on every single aspect of the law if they file an application. Or is it a frivolous application just because they weren't, aware of the most recent case update? So this is a big concern, and hopefully it was one of the parts that we'll see enjoined.
For sure. And another thing, I guess, is just to point out on the bullets here is that adjudicators are not required to allow applicants to explain things so long as they've been, read something, read the warnings for filing a frivolous asylum claim. So presumably that's done in a very monotone voice. The consequences of filing a frivolous asylum claim are blah, 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 blah. And, they're not going to process that. I wouldn't process that, as someone were reading that to me along with another laundry list of things. And then the outlining ways to avoid the consequences. The new rule says, you can avoid all these frivolous findings if you immediately withdraw your application for asylum and waive all of your rights. And it's just, it's trying to kill asylum applications.
Yeah.
So another really strong death blow to asylum is this concept of pretermission. And so the new rule allows immigration judges to pre-termit asylum applications that they deem not legally sufficient. They say that if an asylum application does not show a prima facie case for asylum, that they can pre-termit the application without a hearing. And so you wouldn't even get your final hearing on the merits. A judge can just say, sorry, I don't find this legally sufficient on paper. And so bye, which is very scary.
It's super duper scary. I hate pretermission. I think, so many of the arguments for eligibility for our clients in and out of asylum are best made, in an oral argument, right? And so this idea that if a judge takes a look at an I-589 that we've submitted and says, I think this one element of this application is going to render this person unqualified, I'm going to just pretermit and just kick the whole thing out. It's really, really concerning because, as I mentioned, there's a lot that goes into preparing for a final hearing. Lots of evidence, lots of testimony, lots of trial prep. And this idea that when someone's life is literally on the line, that some judge sitting in his office can read a form about this person's application and decide to deny their case is just nauseating when you think about the potential implications, particularly because the courts are completely backlogged. There's over 1.2 million cases. I think the real problem about this is that the agency is not exercising discretion about who the enforcement priorities ought to be. So there's a different solution for the problem of the overburdened immigration court systems, but understanding that immigration judges are completely overwhelmed. And then they have these processing quotas. This is another thing that's been thrown at them because the immigration courts are not a, judicial branch court system that is a separate, branch of the government. They are actually part of the executive branch, which is one of the worst parts about the immigration system, but that the judges who are, you know, supervised by the attorney general, who of course reports to the president, are told like you need to be denying or processing so many cases per month. Well, a pretermission is a pretty quick way to get a case off your docket. And so this one really bothers me.
Yeah. And, you know, Kate mentioned something about how much evidence, you know, how much evidence goes into an asylum application and that things come out piece by piece. I mean, just a reminder to everyone that, you know, we deal a lot with victims of trauma, right? Like almost all asylum seekers are going to have some significant trauma in their history. And so, you know, you mentioned that people might be seeing a psychologist, and those stories and events get fleshed out over time. And I have met countless people, as I'm sure you have, who have had, for example, credible fear interviews where they didn't tell, you know, they're not going to tell some angry man that a woman's not going to tell some angry man that she's been raped 16 times by her uncle. Like that's just not going to, just very unlikely to come out during, you know, that type of sort of non-neutral and hostile interview. And so this is just extremely, extremely concerning that we're not able to build our cases, and that we essentially have to file everything so quickly for potentially, you know, life-changing decisions. I was mentioning this to my husband, who is an academic and does a lot of research, and he said that they call this in academia a desk reject, where you file a paper for publication and they just sort of dismiss it out of hand. And we sort of agreed, well, yeah, it's like that, except someone dies, right? I mean, the consequences are so great. And to be able to do this to fill a quota is just outlandish. So yeah. Anyway, we're both angry. Can you tell?
Oh man, I'm really looking forward to not feeling these feelings every time there's a change. You know, these last 4 years have just been like, oh, every time something comes down, we're just like, are you serious right now? And so I'm really looking forward to an era where that's not the feeling that we have every time there's a new executive order or regulation. But.
Totally agree. I think we're about to get into lots of changes and more whiplash, but hopefully in the opposite direction.
Exactly. We'll take that. We'll take positive changes all day long.
Yes. Okay, so PSGs, particular social groups. So the first thing that the new rule does is codifies the requirements for particularity, immutability, and social distinction. Kate, do you want to talk just briefly about those?
Sure. So particular social group is the fifth sort of element or way to qualify for asylum. So you have to prove that you have been persecuted, or you have a fear of persecution based on one of 5 protected grounds, which are your race, your religion, your political opinion, your nationality, or your membership in a particular social group, which has sort of been like this, you know, catch-all that includes gender-based claims, LGBTQ claims, maybe domestic violence claims, things like that that don't fit into one of the other 4 categories. And when this idea of a refugee and these 5 protected grounds were first sort of identified and created and codified, you know, post-World War II and in our early asylum laws and in our early case law, it was much, much broader, this idea of what is a particular social group. In fact, our earliest cases talk about gender as a good example of what would be a particular social group. But over the years, and particularly recently, this idea of, you know, the particular social group just gets narrowed and narrowed and narrowed and narrowed and narrowed until it's like, you know, threading a needle to find someone who fits, whose social group fits, you know, within the definition. And so particularly, I think it's the interplay between particularity and social distinction. So immutability means it's something that you can't change about yourself. It's something that's happened in your past, or like if it's about a job that you have, could you just change jobs and not belong to that group any longer, right? But this idea of particularity is that, well, let's start with social distinction, that the group that you belong to is broad and recognizable enough that everyone in your country sees, you know, or knows that you belong to this group because it is so socially distinct, but that it's also particular enough that it's a tiny enough group that not too many people fit into it. So it's like, I mean, nearly impossible to thread this needle of particular social groups. And this, you know, this just sort of codifies through regulation what's happened in the case law recently. And it's really contrary to the idea of asylum and who we protect as part of an international community, an international treaty, whereas as nations, we agreed that we all failed to protect Jewish refugees who were fleeing the Holocaust. And so then we all decided that this is who we protect going forward. And then we just keep chipping and whittling away at it. And particularly as our neighboring countries struggle and suffer. We see, the Trump administration in particular wanting to do everything possible to just cut eligibility for Central American asylum claims. And this is one of the ways they do it.
So one of the things I think that this rule does, we're going to talk about several times, is it defines what something is not, right? It takes common cases, and it basically says those don't count anymore. And so for particular social groups, it says any interpersonal disputes, gang recruitment, private criminal acts. And so, one of the things that I think we'll see as we work along is that they're trying to take basically anything that's not the government themselves persecuting someone and taking it and saying you don't qualify for asylum anymore. Well, that's not the standard for asylum. That's the standard for CAT, and other types of relief that are less generous than asylum. And so, gang recruitment is a common case, especially in Northern Triangle countries where the gangs are taking over and they are trying to get young boys to join them. And that if the boys do not join the gangs, then they'll be killed, as an example. I think that the private criminal acts thing is a dig at gender-based violence and LGBTQ claims. Kate, what else do you see on here that you think is going to be especially problematic?
Well, I mean, this is a list of Central American asylum-based claims. That's what this is, right? So, we see, well, of course, we have asylum seekers from all over the world. Right now we have high numbers of political opinion asylum seekers fleeing Venezuela and Cuba. And then we have a high number of Central American asylum seekers, and most of them are families or children who are fleeing gang violence. And this is the list of Central American asylum claims. So I'm pretty sure they worked backwards and said, who do we want to block, and wrote down this list, and that's how we get it. So all of this, you can just read this together as, okay, there go Central American asylum claims.
Yeah, I think that's probably fair. Political opinion. Okay, so one of the other bases, as you mentioned, Kate, is political opinion. So there's race, nationality, religion, political opinion, and membership in a particular social group. So we just talked about PSGs. Now we're going to talk about political opinion. So they define political opinion, but then they exclude a bunch of stuff, again, including all opposition to all non-state actors absent expressive behavior in furtherance of a cause against such organization related to the efforts by the state to control such organization, or behavior that's antithetical to or otherwise opposing the ruling legal entity of the state or legal subunit of the state. So I take that again to mean that this has to be government and related directly to the government. What else do you see in this?
Well, I mean, we see a lot of maybe police officers, from Mexico, or maybe small leaders of small, areas or regions in Central America who get targeted just because they're in a position where they could be, opposed to gang activity, but they haven't maybe expressly shown that behavior. Maybe just by virtue of their post, they get targeted, and so historically those have been, I think, easier to win, although you do have to show the nexus, the on account of, but this means not only do you have to, be in one of these positions, but you also have to have this expressive behavior, anti-gang behavior, which is like, a really dangerous thing to do. And we'll talk a little bit later about, the definition of persecution. So they've basically said, you have to have really risky behavior, and then you actually have to be like tortured or killed. You know, you can't just be threatened or detained anymore. So it's you know, just one more way they're
Right.
cutting out. Yep, eligibility.
Uphill battle. And that takes us to persecution, like you were talking about. They've now changed persecution and saying that, you know, brief detentions or threats where the threats aren't carried out is not going to rise to the level of persecution anymore. Which basically means that you have to be, you know, beaten within an inch of your life to consider to have suffered past persecution, or at least that is how it seems to read, and how some judges, it seems like, are certainly going to read it.
Yeah, and I mean, you know, anyone who's done a lot of asylum claims knows that this is the way that the people get out, right? Obviously, before they get killed. It's pretty rare that you'll find someone who's detained for a long period of time, or who actually is tortured, and then they get a chance to get out. Most people flee before they get to that level, right, of persecution. So typically, someone will receive several threats, or their children will be threatened. They'll get some phone calls. They'll get a note under the door. Their neighbors will tell them that this person came by looking for them, or the gangs came by looking for them, or they'll be detained in Cuba several times, or, I mean, it's like there's an increase, right? It starts with little threats and then gets bigger and bigger, and people leave, right? When they know that this is real. They don't want to flee their homes. I mean, the majority of asylum seekers would really rather stay home, right? But they flee because they fear for their lives, their children's lives, and they have to get out. And they make the wise decision to leave before they get tortured or dismembered. But now we're saying, like, no, actually, you got to stay until the really, really awful stuff happens. And if you don't die, then you can come, and that's persecution.
Right. And just to be clear, so to win an asylum claim, you have to either prove past persecution or a well-founded fear of future persecution. And, maybe this is specifically addressing past persecution, but I also think that some judges will say, oh, well, you were only briefly detained. You don't have a well-founded fear of future persecution either.
Right. And I think, that maybe could be a good piece of for litigation. Like, so much of this is contrary to established statutes and case law that I am really hopeful that it's so contrary to what Congress and the courts have already said that we'll see some injunctions here. Ideally, a regulation-wide injunction, so it just none of it goes into effect.
None of it. We're going to be hopeful. Okay, so nexus. So nexus is the sort of but for, right? The causational aspect of being persecution on account of a person's membership or a protected ground. Mm-hmm. And so their nexus now, they say that there are 8 bases that would generally not support a favorable application. So again, we go back to interpersonal animus, perceived past or present gang affiliation, criminal activity, and then gender is listed explicitly there at the bottom.
Mm-hmm. Yeah, which it follows what we've already been talking about. This is just a way to put it in the regs that gender-based, like domestic violence claims, single women who are targeted by the gangs because of that status, all gang-based claims are going to fail on nexus under this regulation.
And with internal relocation, again, you'll see a common theme that they're hitting, as Kate was saying, specific types of claims, really from oftentimes specific geographic areas. And so for internal relocation, if the persecutor is not a government actor, then internal relocation is now presumed to be reasonable unless the applicant demonstrates by a preponderance of the evidence that it would not be. And this presumption applies regardless of whether the person has suffered past persecution, as we just saw the major attempts at death blows to past persecution. Now we're looking at internal relocation. And if someone can safely internally relocate, they're no longer, they will not receive a favorable asylum outcome.
And the truth of it is that most of the cases we're talking about today, these gang-based claims, although it's different you know, parts of the gangs, or maybe different, I don't know what you call them, like different chapters of gangs control in different areas, right? There is of this like spider web that crosses, of course, state lines within a country, but it even crosses country lines, which is why, you know, a Guatemalan asylum seeker is not safe in El Salvador, you know, because these gangs have a vast network. And so, you know, before this, if you had past persecution, it was presumed unreasonable to have to relocate internally within your country. And now, you know, that presumption's not there. And you know, I have yet to meet a Central American asylum seeker who was targeted by the gangs or by an abusive spouse, for example, who says like, yeah, sure, I could have just moved a few towns over. I mean, we're talking about tiny little countries that are smaller than many of our states in the United States. And it is just unreasonable to expect someone whose life is on the line to just go hide out, you know, in another town when these networks are very vast.
Right. And from my understanding from speaking with people is you move to a new town, and I mean, everybody knows that you're new.
Right.
And so, you know, if a gang member or someone who's affiliated with a gang has some kind of inside line to anyone in the town, they can get that information and then weave it through the networks. It's very scary.
Mm-hmm.
Discretion. So discretion. So for asylum, you have to merit a favorable exercise of discretion to be granted asylum. It used to be that unless you had some major adverse factor or factors, that discretion was generally something that you didn't have to address much. And now they are trying to do away with that. And so, in fact, our current case law says that, you know, but for the most egregious factors, a favorable exercise of discretion should be found. And so these three factors are factors that judges should consider as significantly adverse factors. So unlawful entry or attempted entry into the United States, unless made after immediate flight from persecution or torture in a contiguous country. So not your country of origin necessarily, but the country in which you are staying, which is crazy when you think about all the asylum seekers subject to the migrant protection protocols that have been waiting for months and months and months and months and months. And some try to enter without inspection so that they can be safe and have food and shelter. That would be a significantly adverse factor. Failure of someone to seek asylum or refuge in at least one country through which the person has transited to the United States. So if you didn't apply for asylum in El Salvador, where I think they have, or at least at the beginning of the transit ban, had 4 asylum officers in the whole country. So if you didn't apply for asylum there, you know, could be a significantly adverse factor. And then if you use fraudulent documents to enter the United States, so like a passport that's somebody else's or something of that nature, then it would be considered a significantly adverse factor.
Yeah, and this just reads, this is just like I was saying, this is like the list of executive actions or presidential proclamations that Trump has made that have been, you know, enjoined or at least caught up in litigation. So that, you know, item number 1, you know, is directly contrary to the definition of asylum that was codified into our statute, into our laws, you know, 40 years ago, that specifically says it doesn't matter how you entered the country. You know, item number 2, that's the transit ban. And I should say that, you know, the executive order, which was they call asylum ban number 1 under the Trump administration, was enjoined by the federal courts. Because the president, you know, cannot change an act of Congress through proclamation or through regulation. And so you know, that's the transit ban. So these are also things that I'm hoping would be enjoined in federal litigation.
Yeah, me too. So then along with the list of 3 discretionary factors that should be significantly adverse, there are 9 that should normally result in a denial. And so, Kate, do you want to talk a little bit about these factors?
Okay, yeah, let me get my brain on straight, because
I know there's a lot of them. Sorry, I totally just tossed the ball at you. And
no, it's fine. Okay, so if so item number one, if they've spent if they've been more than 2 weeks in any country that allowed them to apply for asylum or refugee status, which, so this is like pretty much going to be every single person who comes to our land borders. The only people who would not be subject to this are people who had a visa, right, to come to the United States, and they flew directly to the US and from their country, right? They didn't like pass through another country and fly out of another country. If they traveled through more than one country, the United States. Okay, if they've been in the US for longer than a year, and before they applied, whether they filed tax returns. Okay, if they haven't filed tax returns, that's going to lead to a discretionary denial, which is crazy, because just this August we had another regulation under the Trump administration severely limiting work permit eligibility for asylum seekers. So it's like now we're telling them you can't work, you don't qualify for work permission, but also if you don't file a tax return, your asylum application is going to be denied. Whether they've withdrawn an asylum application with prejudice or found to have abandoned asylum application. And like, this makes me think of a client I had who fled a severe domestic violence situation, left her children in hiding, crossed the border, called the person who was caring for her children, found out that her abuser had kidnapped the children and was starving them, asked to be sent back, and then came back. So that's someone who would receive a discretionary denial. And I don't know if anyone watching this video would have taken a different action. You know what I mean? Like, what do we expect people to do? There's reasons that people have to withdraw an asylum application. And then whether they were subject to a final order and didn't file a motion to reopen within 1 year of change. And that brings up for me a lot of people that I've met over the years who were brought into the country as minors and didn't have control over their hearing, and so they couldn't go, or maybe they didn't know about their hearing. I mean, I've met hundreds of people over the years who were ordered removed in absentia because they weren't ever notified of their hearing. And they don't know about it oftentimes until, years later. And so now if they didn't file a motion to reopen within a year, that's going to lead to a discretionary denial. I mean, it's just,
yeah,
absurd.
Yeah, for sure. So a judge, if any of these 9 factors are present, adjudicator can still find a favorable exercise of discretion in extraordinary circumstances. And it lists in the rule some of those things, but one of the things that lists that kind of surprised me was that you could find extraordinary circumstances, including exceptional and extremely unusual hardship to the applicant. And my first sort of knee-jerk reaction was, well, aren't all asylum applicants going to show exceptional and extremely unusual hardship if you're going to otherwise grant it for discretionary issues? This is also the standard for cancellation of removal for non-permanent residents. It has to be exceptional and extremely unusual hardship to a relative of theirs. But this is an interesting thing to sort of inject into asylum cases. And I do actually think that if this goes into effect, there will be, maybe 1 or 2 sympathetic judges out there that will use this, sort of as an out if they want to be granting asylum cases where 1 or more of these 9 factors are present.
Although if it's a Central American asylum seeker, the judge may find that there's going to be hardship, but they're going to fail on one of these other, nexus, other issues,
I'm trying to find the silver lining.
I know. I mean, and I'm a positive person, but like, this is really, really bad. So.
Yeah, no, it's terrible. I hear you. I saw that and I was like, really? You're going to give an out? Okay. But then you have so many other ways, for the case. Okay, so firm resettlement, which is different from obviously internally relocating in your home country. Firm resettlement is settling in a third country. So not the US, not your home country, but a third country. So it changes that. Hey, shocker. Okay, and says that now you can be found to be firmly resettled in sort of 3-ish different ways. And so the first is that the person resided in a country through which they transited prior to arriving in the entering the United States and received or was eligible for permanent legal status in the US, or excuse me, in that country, which has been, right, sort of the standard all along. But then if they resided in such country where they had any non-permanent but indefinitely renewable immigration status, or resided in that country and could have obtained any non-permanent but indefinitely renewable immigration status in that country. So basically it's saying that no longer is it just permanent status, but it's indefinitely renewable status.
Which is crazy.
Yes.
Like, that is not being firmly resettled, does not mean, oh, you could have been firmly resettled, you know? I mean, it's like the firm resettlement rules historically make sense, right? Like, if you have lived in another country in which you are safe and you had a permanent legal status in that country, well, then it's, you know, you can't claim that you're unsafe solely on the basis of, you know, your originating country, right? But this idea, this is the transit ban, you know, placed into the firm resettlement rule that, you know, basically it's just another way of saying you pass through another country on your way to the US and you can't apply for asylum in the US.
You could have applied for asylee status and you didn't, right? And then this one scares me also. So this doesn't require any lawful status. It says the alien person, human being, physically resided voluntarily and without continuing to suffer persecution in any one country for 1 year or more after departing his country of nationality or last habitual residence and prior to arrival in or entry to the United States. So for the migrant protection protocol folks, where they have traveled, you know, up to Mexico, presented themselves at the border, were given a notice to appear in immigration court, and then sent back to Mexico, and then they've been waiting for over a year. Are they considered to have been arrived in the United States when they come for their final hearing, or are they considered to have arrived in the United States when they first hit Mexico? And is DHS going to be arguing that they physically resided voluntarily in Mexico when in fact we all know that's not true?
Yeah, I mean, there's two, I think, you know, arguments for an MPP applicant or victim, you know, that their arrival date, they arrived in the US, right, when they applied for asylum. And then I think for sure if they got sent to MPP, it's not voluntary, right, that they're staying in Mexico, but you bet DHS would make that argument. So again, like, hopefully this gets enjoyed.
So depressing. I know, it's just like the constant theme of like, hopefully this will never be actually a thing. The third showing. So if the person is a citizen of a third country and traveled through that third country prior to arriving in the United States, or if the person is a citizen of a third country, traveled through that country, and then renounced citizenship in that country prior to or after arriving in the United States. I think this is basically saying now, you know, you can't have citizenship in a third country where you could potentially go live and then renounce it so that you could get asylum status.
Right. And like, you know, if someone were to ask me, okay, what part of this 400-page regulation could we live with? It's this. This is it, right? Somebody has a, you know, dual nationality, and they, you know, renounce a citizenship to, let's say we've got, you know, a Venezuelan who also has German citizenship, and they want to come to the United States, so they renounce their German citizenship and they try to apply for asylum based on political persecution in Venezuela. Well, I can see that we as a nation will be justified in saying, well, you know, you decided to renounce your German citizenship and you probably would have been safe there. So if we're going to keep something, this is what I choose.
Out of the thousands of asylum seekers that you've worked with, how many people, in fact, have you encountered that have dual citizenship?
No, well, I've encountered a lot who have had dual citizenship. I have encountered none who have, you know, strategically renounced one of their citizenship so that they could qualify for asylum.
Yeah. Public officials. So going back to political opinion claims, and also specifically talking about claims for relief under the Convention Against Torture. So this takes the phrasing rogue officer and changes it to not acting under the color of law. Okay. But then it talks about how the person has to be acting in their official capacity in order for them to be considered a public official. It's not enough that they were mistaken, recklessly disregarded the truth, or negligently failed to inquire. They must have knowledge or willful blindness. And then acquiescence requires an omission that the official had a duty to do something that they were able to do. So again, just sort of chipping away at all of these claims. I think specifically in cases where gangs and public officials are in cahoots together, and potentially, domestic violence claims as well.
Right. Like, I've had a lot of domestic violence applicants whose abusers were, politicians or police officers. Right. And so if they're at home being abusive, I think, and this is getting at those situations and at gang or police officers who may be, bribed by the gangs or politicians. And when they take activities in support of the gangs and persecute people, this is limiting the victim's eligibility to apply, even though they were targeted by someone in power,
Yeah, no.
It's like the difference between whether they were rogue or whether they were acting under the color of law, like that doesn't actually make a difference to the victim in the level of threat that they were under.
Right. Okay, so everything's so awful. What should we do about it?
No, and this is what we need to know, right? This is bad, really, really bad, especially for Central American asylum seekers. We think it's probably going to get enjoined pretty soon after it gets implemented on the 11th of January, which is 9 days before Biden takes office. So hopefully it'll get enjoined really quickly. If not, hopefully Biden will roll back the regulations, but he would have to follow the Administrative Procedures Act and, do a proposal and a notice and comment and a final regulation. So if there's no injunction, there is going to be a window of time where these regulations are in effect. And so those of us who are who have asylum clients, or who, if you're watching this and an asylum seeker, or you are an asylum seeker, this January 11, 2021 date is the date to know that the 589 has to be received before that date in order for these new regulations not to apply. So that means you submit it to the court or to USCIS on the I-589 before January 11, 2021. And if you file after, you're subject to the new regulations, and pre-dermission and all this nonsense applies, which means probably you can't just file an I-589 anymore. You have to file an I-589, with a pretty detailed affidavit from the client, with probably some evidence and probably a legal brief, so that you don't get pre-dermitted. And you got to do all your research on the case law so that, you don't submit a frivolous finding. So we've got a rush situation here, but we also need to be really aware, 3 weeks from now, what it looks like to submit an asylum application versus what it looks like today.
Right. All right, team. Well, that is all we have for you today. If you have questions, you are welcome to email myself or Kate to follow up. We're also happy to shoot you the slides if you want copies of the slides. I'm going to go ahead and stop the share on the PowerPoint and see if we happen to have any questions online. I don't think that we do. Do you see any?
I don't know how I would see them, but while you're looking, let me just make a final comment about VECINA. So I'm a private immigration lawyer in Austin, and I serve on the board of VECINA. Lindsay is the CEO. She was a private immigration lawyer like me. And when the family separations happened, she and I talked a lot during that summer. And she said, I just feel like I got to do something. Something's got to be done. And she did it. She launched this organization that is really innovative and special, and that it pulls resources from all the important places that are overburdened in their own ways, right? So the organizations on the ground that are interacting with the migrants don't have capacity to recruit and train and mentor pro bono attorneys. So Lindsay works with VECINA works with these organizations on the ground to get the cases she does all this recruitment and training for pro bono attorneys all around the country who maybe have never taken an asylum case. And she has this whole library of videos on how to do it. She's a lot of work. And then she works with experienced immigration lawyers as mentors who themselves are overwhelmed and can't maybe take a whole pro bono case, but they can certainly guide a pro bono attorney. So it's like pulling the resources from all of the important places to increase access to justice and dignity and representation for migrants who are under attack in this really, really dark time. Is such an innovative and special thing. And it's a small organization, and a little bit of money goes a really long way. And it's December 18th. And for anyone who's like, I got some end of year giving to do, I get a lot of questions about this from people in my life. I got to do something. Who do I give to? Give to VECINA if that is your question, and you want to do something about migrants, because it is such a special organization. And there's going to be a lot of work in the years ahead clawing out of this hole. So like if Biden ends the MPP program, there's going to need to be a system to help process in all of these asylum applicants, and VECINA and Lindsay are going to be there with this small, nimble organization ready to react and do the important work that needs to get done. So that's my plug.
Thank you. That's so appreciated. Yes, we love what we do. Stuff like this is depressing, but it's also inspiring to rally the troops and see so many awesome people and attorneys stepping up, ready to help, even if they don't have prior experience. Also, if you want to volunteer, we do mentor and train pro bono attorneys that don't otherwise have immigration experience. So thank you guys for listening today. And happy holidays to everyone. And hopefully they are not completely filled with filing 589. All right. Thank you so much, Kate.
Bye. Thank you.